Ladies and gentlemen, welcome aboard the Wright Flyer. I'm Randy Wright, and I'll be your captain on this solo flight special edition of our state-of-the-art radio program. This is the final boarding call, and I cordially invite you to please claim your seats, fasten your seat belts, kick back, relax, and enjoy the show while I go ahead and delve into the pre-flight checklist, because there really is a lot of news and information to get to before I may fully indulge you with your in-flight entertainment. Folks, if there is one thing that we can say about technology and the rapid expanse thereof in modern society, it's that we have a love-hate relationship with it here in America. There can be no question that technology has vastly simplified the mundane tasks of our daily lives, but there is also the risk that it will infringe upon the fundamental and unalienable rights of the American citizenry. We've already seen, with respect to technology, that anonymity has been all but lost. I'm sure you all recall back in 2013 when former NSA contractor Edward Snowden blew the top off of the fact that the National Security Agency had been collecting not only metadata information about American citizens without first procuring a warrant, as would be required by the Fourth Amendment to our United States Constitution, but also more in-depth information. We also learned that the NSA was building a new storage facility in Utah, I believe it was, to store as much information as humanly possible. Irrespective of this fact, we also learned that the NSA snooping programs really weren't all that effective in stopping things like the Chechnyan Mario brothers, Dzhokhar and Tamerlan Tsarnaev, from carrying out their twisted and nefarious Boston Marathon bombing plot back in the same year of 2013. Now, another area of privacy concern that overlaps with our fundamental and unalienable right to own and hold property is coming to the forefront. This comes out of a Washington Post story that was written by Andrea Peterson and Matt McFarland. It's entitled, "You May Be Powerless to Stop a Drone from Hovering Over Your Own Yard." So what this case revolves around is a man named William Meredith who lives in Kentucky. There was apparently a hobbyist who was flying a drone over the property of Meredith, hovering it just above the property because he claims that he was looking at scenery. Now, Mr. Meredith had reported the unidentified craft to the police on multiple occasions, and he finally got fed up with the basically unmanned craft hovering over his yard and grabbed his Borelli M1 Super 90 shotgun, which, by the way, is a fantastic firearm, and shot 3 rounds of birdshot into the mechanical tweeting nuisance. It was a quadcopter model which had a camera, and this drone was basically intruding upon the privacy of the curtilage, meaning the area around the house of Mr. Meredith. Apparently, the hobbyist goes by the name of John Boggs, claimed to authorities that he was merely trying to take pictures of scenery, as I had previously mentioned. He's now filed a lawsuit in the Louisville District Court against the property owner, Meredith, for damages sustained to his pilotless craft. Now, this has been something that hasn't really come to legal attention in such an extent before. After all, for decades, the nation's air didn't matter, or rather, who owned the nation's air didn't really matter much to your average, everyday Americans. Planes are very heavily restricted in the type of airspace that they can fly and the height at which they are allowed to fly. Yet, with this idea of technology, the drones that are now available to, private citizens and law enforcement agencies alike are raising some serious and significant legal questions. And so now we have to wonder whether our legal doctrines that are currently on the book are up to date or are capable of handling this, or whether they are rather antiquated. And you have to keep in mind, with respect to legal developments, our legal system, due to the cumbersome nature of law in general, is practically medieval, very slow at moving to adapt to rapid-paced changes, and technology has just been a true problem for them, because in a way you really don't want a legal system that can just so easily, rapidly adjust to things, because you want the legal system to be very thorough in its investigations and approaches to ensure that our fundamental and unalienable rights are not encroached upon. And with respect to the drones, that's where it's one of those areas that competes with the idea of a methodical legal system, because technology just moves so rapidly that it really would take forever for legislatures to draft and adopt proper resolutions and responses to the concerns that were previously unheard of. I mean, just stop and consider for a moment just how much computer technology has changed over the past decade. And not just computers. Look at the mobile technology. We've already seen the development of people not paying attention to their surroundings, walking off cliffs to their deaths, being glued to their smartphones, people walking out in front of fast-approaching automobiles only to be struck and killed, texting and driving. All of these problems are unique and new and wouldn't have been thought of prior to the development and adoption of this rapid-fire technology that keeps us instantaneously connected. And, of course, one of the areas of major concern with respect to rapidly developing, transforming, and evolving technology is our right to privacy. And, again, it ties back into the private property ownership issue. In the United States, our property law views the ownership of property and property rights as like a bundle of sticks, meaning you have a series of rights that are individual, separate and apart from others, but that are bound together in the general notion of owning property. And one of those private property rights is the ability to exclude those whom you don't wish to enter upon or intrude upon your property from doing so. This is your classical trespass doctrine. And there are questions as to whether these drone intrusions could be argued under classical nuisance theory and trespass doctrine. And so, before I go a little bit deeper into the story that brought this to my attention, I think it's important to kind of review just what a nuisance is and what trespass doctrine is, because in legal parlance, it really is a bit more nuanced than what you might see in your general vernacular or the generally used definitions. So, in its most basic definition, trespass is defined by the legal dictionaries of Black's Law as an unlawful intrusion that interferes with one's person or property. So it's any type of unlawful intrusion on your physical being, your clothing, your body itself, or your property which belongs to you. Now, this originated with English law and was an action of trespass, and it was initially any wrongful conduct which directly caused injury or loss. So that means any of your modern tort law would have been argued in the early days as a trespass, but that's changed because it's been narrowed as negligence came to parlance in our tort law system, and the trespass law was basically narrowed in its scope of applicability. So basically, in modern law, trespass is an unauthorized entry upon land, and it gives the aggrieved party the right to bring a civil action in order to collect damages as compensation for the interference to and from any harm suffered from said trespass. So it is an intentional tort, meaning that the person had to intend to intrude upon the land, and in very rare circumstances, it can also be punished as a crime. So here, with respect to Meredith's claim, it's got to be difficult if he were to bring a trespass claim, say in the form of a countersuit, against the damages to the drone which was hovering over his property, because he would have to show some sort of intent. Lack of intent would negate the tort of trespass. That being said, we really don't know how drones would apply to this, because someone intentionally has to fly a drone, someone must know where the drone is, and someone was intentionally trying to take pictures, but they didn't first receive permission from the property owner. Of course, another area that is of major concern here with respect to this is what exactly would be the property ownership right of air, because that too is kind of a gray area in the law. Perhaps the stronger claim that a property owner like Meredith could bring against the use of a drone on his property without first, procuring his permission to allow it to fly over his property would be nuisance law. Now, nuisance is defined by Black's Law as a legal action to redress harm arising from the use of one's property. And it's important to know that there are two types of nuisance. There's a private nuisance, and then there's what's known as public nuisance. Private nuisance is a civil wrong. It is the unreasonable, unwarranted, or unlawful use of one's property in a manner that substantially interferes with the enjoyment or use of another individual's property without an actual trespass or physical invasion to the land. Now see, it's going to be kind of questionable here as to whether a drone would be a physical invasion of the land or not, again, centering around the ownership of the air doctrine. Now, to differentiate that, a public nuisance would be a criminal wrong. It is basically any act or omission which obstructs, damages, or inconveniences the right of the community. Now, that's an interesting question as to whether drones would fall into that category or not. In the case at bar here, I don't think that would be the case, because it is involving the private property of the individual private landowner, more so than the community at large, but you can easily see how the flying of drones over private property and even public property in such a way that inconveniences the rights of the community would really bring it into the parlance of a public nuisance. And again, it just goes to show that while the law is antiquated in many fashions, it can address these sorts of things, but you have to be creative in your thinking about it. Your thought process basically has to go outside of the box, and you have to think about it in ways which were previously unimagined. But the main impetus behind this story and what's going on here is that it's bringing into the question of who owns the air. And I know that sounds very strange to say that, but there's a lot that goes into consideration with this. Because drones can take off or land almost anywhere, and tech companies dream of using them to deliver goods to our dwellings, it really has ignited a debate over who exactly owns the air just above ordinary homes and lawns, or the curtilage, as I had said earlier, in the United States. And so this really is kind of a privacy concern that is bubbling up to the forefront and the center of national attention, because it is something that will need to be resolved as drones become more and more commonplace. Because I think they said as of last year, according to the Consumer Technology Association, it has been estimated that 700,000, just a little over, 200,000, over 500,000, were sold last year alone. Folks, that's staggering. It shows that this area truly is expanding and growing, and it does raise some serious private property ownership rights concerns, and the legal system will actually have to address this issue. Because, there are other potential areas of tort law where this could come in, seeing as these drones are affixed with a camera. They can easily be considered to invade the privacy. Peeping Tom laws would probably apply if some pilot hovers the drone in such a way that it peers into the dwelling space of an individual, and that too is kind of a major problem. And what's so amazing about technology is that we have seen it drastically change the way our lives work, because we've seen with smartphones the kind of changing etiquette that is evolving with respect to it, because people no longer communicate in the way that they used to. This instantaneous connection to one another at all hours of the day has really become a complete and total immersive type of event and situation, to where you have to wonder, what are the negative impacts that this has on our lives? And how are we going to address a code of conduct, or devise a code of conduct, to respond to this drastic, major change to our lifestyles? I think that it should be adopted in such a way that it's, a code of conduct, if you will, a type of cordiality. But that's going to be very difficult, because we see that the way the country is operating right now, there really is a lot of moral decay. We don't know proper decorum much anymore, and formal society has laxed to such a degree. And then we see with things like the Fabian socialist attacks on our traditional institutions that there is just this great hostility and negativity towards traditional aspects of polite society and culture. And therefore we see the breaking down of society, this general morass of morality decaying all around us. And it's just a direct indicator that our society has not adapted well to this rapid emergence of technology. And on top of that, our legal system, as I have previously mentioned, just has failed to keep pace. It would be a very daunting, I believe, damn near impossible task to ensure that the legal system is able to keep up with this technology that is evolving so fast that you even see technological fads and trends develop. Think back to the release of the Google Glass, or those Google Glasses. There were very large concerns for a while that would cause all sorts of invasions of privacy and would further disrupt the boundaries of civil and decent society. But apparently, wearable technology just hasn't caught on like these massive tech companies thought they might or would. And so that too is creating an interesting rift that we're seeing in society. And again, the legal system was caught off guard. And because the legal system moves at such a snail's pace, I think you're just going to see more and more and more of that as society continues to evolve at a breakneck pace. But back to the story at hand. there are gray areas in terms of how far your property rights extend. And that's very true. In the article that came from Jeremy Scott, who is who is of the National Security Council at the Electronic Privacy Information Center. It's going to need to be addressed sooner rather than later as drones are integrated into the national airspace, he said. And he's absolutely right. But, you know, the traditional, what is known as common law approach, because it wasn't really devised by statute, it was decided in legal disputes between parties as to the private property doctrine, had a very unique approach to just how much of an extent the landowner's control of his or her property extended. The original Latin for it was Q est solum ius est usque ad colium et ad infernos. Now, what that roughly translates to is, for whoever owns the soil, it is his, all the way up to heaven and down to hell. So, basically what you see there was this notion that a person who held a piece of real estate, which is your property, held rights to it, including the mineral rights, all the way through the ground and up to the sky. Now, where this has changed was with the advent of aviation 112 years ago. Back when the Wright brothers first put the airplane into the air, this really did start to raise some significant legal questions. And what this also shows is that with each advancement of technology, there is always initially legal gray areas because nobody had previously thought of this. That's not to say that people hadn't thought of flight. Surely they had, because you remember Leonardo da Vinci and various other artists and inventors were attempting to address this issue going back hundreds of years. Man has always dreamed of flight ever since he first peered upon flocks of birds flying effortlessly in the heavens. But what was so amazing in 1903 was that we actually had a powered, heavier-than-air craft that could push man through the air in effortless fashion, like what we saw with the birds. But that did raise some interesting legal questions. And it's becoming a very urgent issue with respect to drones because, as I had said, 700,000 of these things were sold last year, and then the FAA, or the Federal Aviation Administration, says that every inch above the tip of your grass blades is government's jurisdiction. Now see, folks, this is where the federal government once again begins to encroach upon the fundamental and unalienable rights of the citizens. You go back to the original property law doctrines, and you have the ad colium doctrine, which, as I said, claimed that whoever held the land in ownership held rights to it both under the ground and above the air. But with the FAA, which developed as commercial aviation became more abundant and popular, they started to encroach upon the private property ownership rights of the individuals. And it's almost, in a way, similar to the type of dispute that's happening with respect to the Bundy issue, or the ranch issue, where the militia is held up in that Oregon nature or wildlife reserve or preserve, because it's a federal organization or entity, agency, telling you what you can or cannot do with your property, where traditionally property rights, as per the bundle of sticks doctrine, meant that you had absolute control over the property, so long as you weren't infringing upon the fundamental and unalienable rights of your fellow citizen. That has always been the natural law application of the fundamental and unalienable rights which were endowed to us by our Creator. That was a quintessential part of our founding process. It was considered to be the fundamental and unalienable right of the people to own property. That's part of the pursuit of happiness. That is how our founding fathers interpreted it. And we see that the federal government is acting in a way which is totally, completely, wholly, diametrically opposed to this traditional notion. And you have to remember that the FAA is responsible only for the safety and management of U.S. airspace from the ground up. And that's according to an agency spokesman who echoed rules laid out on the website of that place. But again, we look back to the common law holdings that really did establish that landowners' rights went all the way to heaven. And today, it's clear that we still have some of those rights. And one of those rights would be to exclude unwanted trespass from your property. Because the curtilage or the area surrounding the house is still a very private affair. But again, the courts have, with respect to law enforcement officers using that, chipped away a lot of the meaning of the Fourth Amendment. And again, folks, this shows why it is so drastically important and imperative that we all have a fluent working knowledge and understanding of our shared Constitution and also our fundamental and unalienable rights. Because it is to the point now that technology has developed at such a breakneck speed that we have to take into consideration the fundamental and unalienable rights of the people. Because if the technology is utilized in such a way as to encroach upon the fundamental and unalienable rights of the citizens, we are going to lose the complete meaning, application, and definition of law. And that would spell disaster for the country. And not just the country, but for individuals. So, we do know that developers and cities have been able to sell off rights to the airspace just above their buildings. And I'm sure you all know also that when a neighbor's tree or some obstruction from their property hangs over to your property, you can remove or chop down the part that is intruding upon the airspace of your property. But again, we have to wonder what the FAA is going to try and do with this when they claim absolute ownership of the air just 1 inch above the blade of grass. If you stop and think about that, if there is someone who has malicious intent in the government, which is not hard to imagine when you look at the current regime occupying the White House, they could say, look, the house is above 1 inch of the blade of grass, and therefore we own the roof, we own the house, or any structures or what is legally known as improvements on the land, and we can just come in and take it. Of course, that would violate so many other areas of the Constitution, but I'm just throwing this out as a hypothetical example to show how the loose interpretation of regulations and laws would come into play here. And, looking back to the proposed constitutional amendments put forth by Texas Governor Greg Abbott, the idea of being able to say no to federal executive, what's known as administrative agencies, being able to compile binding law would be a great step in the right direction to help curtail a lot of this infringement and encroachment and abridging of our fundamental and unalienable rights, particularly when it comes to the fundamental and unalienable right to keep and own property. And if you stop and think also, it would help prevent a lot of the attempts that they've put forward in an attempt to infringe upon our fundamental and unalienable right to keep and bear firearms. You see, folks, all of your constitutionally guaranteed rights, and indeed all aspects of the Constitution, intertwine. It is basically a legal impossibility to pick and choose certain parts of the Constitution that you wish to apply. And that's why I have said on previous episodes of the Wright Flyer that it is such a dangerous thought process to try and look at something like the Second Amendment as being antiquated, because then you can say that about any and every part of the entire Constitution, which belongs to the ultimate wielders of sovereignty, we the people, and say that the Constitution is now going to selectively apply. Now, folks, what you see there is that starts to become a bill of attainder. It starts focusing on certain specific groups, then it starts trying to apply an ex post facto type mentality to it, and therefore I think that the answer to this sort of invasion of privacy that we're seeing with these drones doesn't necessarily call for new law, but would be covered by public nuisance doctrine. After all, even within the Fourth Amendment, even though that applies specifically to government, you can take the intent of the Founding Fathers with respect to this idea that people are particularly free from unreasonable searches and seizures upon their houses, papers, persons, and effects. Well, the houses, meaning the house, the property around it, the curtilage, would apply. Now, of course, the courts have whittled that away in their various attempts to give law enforcement agencies and officers expansive power to say that anything you do in an open field that can be seen by an aircraft, well, because you don't own that air right, then the government can move in and arrest you or just fly over, take pictures, and they don't have to procure a warrant for that because it's not technically a search. But if you go back to the original intent of the clear and concise language contained within the Fourth Amendment, you see that that doesn't really fall into line with the way that the Founding Fathers thought. And then if you expand that into the way that they felt with respect to the House, especially with the quartering of troops tying into the Third Amendment, you can see that no, they really did expect there to be privacy, not just within the confines of the actual dwelling structure upon the land, but the land itself. Because once again, one of the bundle of sticks in your private property ownership rights is the power to exclude people from your property. You have to receive permission. And again, the private nuisance doctrine comes to mind here as being applicable to this type of scenario or situation. Now, it is interesting to state that looking back to the 1940s, we see that the Supreme Court has dealt with a case in a similar fashion to this, although not entirely on point with respect to the drone issue. That case is United States v. Cosby. And what was there is we see a farmer bringing a lawsuit against the federal government for low-flying military planes taking off and landing from a nearby airport. The farmer contended that the planes forced him out of the chicken business, and he wanted compensation. And the courts agreed, and they gave it to him. I guess the noise disrupted their ability to lay eggs or would work them up into such a frenzy they'd kill each other. But whatever it was, it clearly infringed upon his ability to what is known as the quiet enjoyment of land, meaning the full enjoyment of his property rights. And you see, that falls directly in line with the constitutional and natural law approach to our fundamental and unalienable rights that our founding fathers approached things with. Because if you stop and think about it, the only time that your rights can rightfully be abridged or taken away is when there has been an encroachment upon the fundamental and unalienable rights of another citizen, and there has been an adjudicated removal of the rights pursuant to proper due process under the law. That is the way that a free, open, and honest legal system would have to work. And that is the way that for a decent while the United States court systems worked. But we see now that there are ever greater concerns with respect to the government's unfettered attempts to spy on our privacy, and as we get more and more interconnected and smart homes and whatnot, there's these arguments that warrants have to be pushed aside, and then there's the idea of, well, who owns the air? We know that organizations like the Army Corps of Engineers have attempted to claim ownership over any water that can be quote-unquote navigable, meaning that you can navigate it, but their definition of that can include wetlands or dry creek beds that are only, filled with water at a certain point in the year or after a torrential downpour. And that is really a troublesome area to look at, because what it really is tantamount to is the government slowly creeping in and amassing greater and greater power for itself at the expense of the true ultimate wielders of sovereignty in this country, we the people. And that's a problem that's not really being addressed, and I don't think you're going to see the graduates of Pavlov's School of Journalism for the salivating mainstream media really approach this, because it doesn't go in line or march lockstep with their twisted agenda, which is to push forward this radical Fabian utopian socialist creeping infringement upon our rights further and further and further along. And we can see this in the way that they cover certain stories and the type of editorialization that we see applied by the salivating mainstream media with certain particular individuals and certain particular cases. But it's interesting to note that when you stop and think about this, it really does raise significant private property ownership right concerns, and it's not something that can just be swept under the rug. I'm sure that the graduates of Pavlov's School of Journalism for the salivating mainstream media would absolutely love to be able to simply ignore this, but, the first time that they'll come out and actually consider this a serious threat or problem is when it starts to infringe upon their own personal rights. And that's funny. If you ever watch the salivating mainstream media, you can see that they get special attention or give special attention to members of their own profession, and that they will try and go out of their way to protect those individuals and to cover them in a positive light and to champion them as heroes. But the fact of the matter is, the salivating mainstream media has not been operating in a fashion which I would consider noble or heroic. Because of the double standards that we have seen, because of the unfair editorialization that we have seen on the part of the salivating mainstream media, we can say that they have been complicit and collaborative with the federal government's efforts to encroach upon the fundamental and unalienable rights of the citizenry. And I have to admit that I have a major, major problem with that. Now, another way that this could be an area of concern with respect to the fundamental and unalienable right of the ownership of property is personal property comes into this as well, because the drone operator did own that drone as personal property. And so there really is a clash of fundamental rights here. But traditionally speaking, the privacy of one's home and the curtilage around their house has always been a more significant right. And so a values-based judgment does have to be applied, but that can be tricky too. But still, it's both dissettling or unsettling to see this, and fascinating at the same time, because in many ways the way that the law adapts to this sort of thing is amazing, but the way that government can encroach upon the fundamental and unalienable rights of the citizens can be alarming as well. And we have certainly seen the government do its fair share of dubious and questionable behavior. But as we see from the United States v. Cosby case, there really is a set precedence with this. And the one thing that the court also held is that a property owner owns at least as much of the space above the ground as he can occupy or use in connection with the land. So that's already clashing with the FCC's claim that they own the air from 1 inch above the blades of grass within the property. And so that interesting clash of ideologies here and terms and definitions is definitely going to be interesting, because if the government continues down this path that it has been as of late of just adding more and more draconian red tape and overzealous regulations, I think we will see a type of major clash occur, and it will have to be decided by a court battle, even though it really shouldn't be, because the idea of strict adherence to our shared Constitution should be the central and paramount application of interpretation with law. And again, the Constitution itself is not really open to interpretation. Now, I know that the courts like to claim that they can do that, but again, if you look at the Ninth Amendment, it strictly prohibits so-called interpretation of the Constitution. Because remember, it says that the rights cannot be read in a way to disparage or deny other rights. And unfortunately, that is kind of what you are seeing with respect to the FAA's interpretation of the ownership of the air. And the other aspect about that is it's saying that the air is totally the public domain. But if it's public domain, that obliterates the idea of private property. And there really are concerns right now that the notion of private property ownership, with the abuses of taxation and the way that the IRS has been acting, but not just the IRS, also with property taxes and the ability to take property in those states like California, which no longer have homestead acts, it raises some significant questions too. And that is why Jeremy and I so ardently advocate for a return to strict adherence to not only the natural law tenets that underpin our entire representative Republican form of government, but also the Constitution itself. Because if we deny those rights, we have nothing. We absolutely have nothing, and we are returned to a state of serfdom. And I think that that's why Alexander de Tocqueville and yours truly have said that basically when you look at the socialist mentality, it really is a form of New Age feudalism, because they want to micromanage the facets of your day-to-day life to such an extent that you have no say, that everything is done in a collectivist manner, and the individual's sovereignty, what is known as popular sovereignty, is eroded to a point of mere meaningless. And we have seen the government march in such a way. And so, with the case of the drones, we see that even though the Cosby Court made the ruling that they didn't clearly define a precise aerial boundary for landowners. So this again leaves a gray area and bogs the drone operator wants to try and clear this up for the burgeoning drone market. And his attorney, James Mackler, who works with the firm Frost Brown Todd, said that the industry is growing quickly, and it's to some extent being stifled by the legal uncertainty surrounding these issues. So yes, I do support trying to find these issues out, but I think that the area of law when it comes to private property ownership has been decided. Unfortunately, I think that the way that the government has been meddling with our fundamental and unalienable right to keep and own property has, created this sort of uncertainty that we're seeing. And, it also raises the question that if technology companies want to deliver goods to the front doors of customers, it will need to be clarified as to where they can fly, when they can fly. But again, I think that the existing legal structure already aptly allows that. under the doctrine of invitee. If you invite someone to the property, such as you would any type of regular delivery person, wouldn't you also have invited the drone to leave the box or the package? And once they leave that and then go, it's not right for them to just stay and hover at the place and get ownership data or data concerning the ownership of the land or information about the landowner, because when the task is complete, the invitation lapses. And so that is kind of a clearly decided area of the law already. And, one of the concerns that was raised by Boggs' attorney is if you were having a drone delivering a package to your neighbor, would it be able to fly over your yard at 50 feet? Or would it need to descend vertically from hundreds of feet in the air to avoid trespassing on your airspace? Now, that is an area that would need to be cleared up. And that is what the court systems are for, is to clear up the vague ambiguities that exist within the law, because the law cannot just anticipate every situation. We wouldn't want a law that is arbitrary and capricious in its application and, the total outlook which the government takes with respect to it. Now, as previously mentioned, Boggs is attempting to sue Meredith, the landowner, in an attempt to recover, I believe it's $1,500 for damages to the drone. But he wants a judge also to decide whether his drone had been trespassing over Meredith's property, or it was flying within the jurisdiction of the federal government. So once again, folks, we see that there is a clash between the rights of the popular sovereign and the federal government. It's completely out of balance with respect to the way that our founding fathers intended for the government to work and for the rights of the people to interact with one another. Now, one of the interesting things with respect to the federal government, it's funny, when you say that the federal government can own property, what you're really saying is that the property belongs to all of the people. Again, that is why the Keynesian, Fabian socialist types like to use these vague and ambiguous terms. They make people feel all warm and fuzzy inside as they attempt to convince them that what they're really doing is expanding their own property rights, but in fact they're not. The federal government then acts as though it is an individual unto itself with specific bundle of sticks property rights, and the stick of exclusion belongs to them, and therefore they can keep people off or restrict the use of property. That is tantamount to a type of tyranny and despotism which our founding fathers loathed and despised. So we see that we are encountering these sorts of problems, and I think it's interesting that it would come up in a type of story like this. Now, I'm sure many of you are also wondering why it is that Meredith, the property owner, didn't face any criminal charges. Well, that comes to a discrepancy in the facts. You always kind of get this he said, she said type thing in courts, especially when it comes to contentious and heated disputes like this. The complicating factor for Boggs is that he and Meredith tell different stories about the day in question. In Boggs' suit, it says that the drone was about 200 feet above the ground, a claim that he previously said was backed up by images captured by the craft. Now, I've noticed that the article doesn't show any of these images, or doesn't expand upon it, other than just including that little quip there. Meredith and numerous other eyewitnesses have said that the drone was much closer to his home, and a local judge agreed with him by dismissing the criminal charges against him back in October. And again, that local judge had relied upon numerous eyewitness accounts which supported Meredith's claim more so than Boggs. So, what this all comes down to is that is the way that the court system was working in proper fashion. It was interpreting the facts in a fair, even-handed manner, which ensures that the rights of the individuals are preserved as they are meant to be. But there are still lingering questions with respect to quote-unquote federal ownership of the air, and that's something that just isn't going away, and I think that it will become more contentious, especially when you consider the types of contentious disputes that are occurring, like in the state of Oregon, with respect to those ranchers who had previously obtained permission from the Federal Land Management Bureau and Malarkey Bureau to do what we call underbrush burning, these set fires to create a fire line and prevent massive destruction of property. And the way that the federal government was acting in such an abusive manner is startling. And then when you take into account just how much of the land in our westerly most states are actually owned by the federal government, it's shocking, staggering, and it's something that needs to be reversed, because we have to return to strict adherence to the fundamental tenets of our shared Constitution, because popular sovereignty has come under a direct assault, and that in and of itself, per se, goes against the foundational vision that our founding fathers had when they fought so hard to establish this country over 200 years ago. And this is why Jeremy and I say that the natural law tenets that underpin our entire Constitution, and indeed our entire representative Republican form of government, are timeless, is because they apply just as equally today as they did 200 years ago, as they will 200 years from now. But the federal government doesn't like that. Those that want to expand the scope and application of government beyond the wildest dreams of the founding fathers will do anything to obfuscate the truth and to amass in an illicit fashion even greater power unto themselves at the expense of the ultimate wielders of sovereignty, we the people. That is something that we have to be very aware of, because they are tireless in their efforts. They are incessantly pushing to wrangle more and more power and weaken the true ultimate wielders of sovereignty, we the people, with each step. So, with respect to this idea or question of exactly who owns the air above private property, we know that Congress had tasked the FAA back in 2012 with apparently integrating drones into American skies. So they were primarily focusing on securing aircraft safety to prevent mid-air collisions between unmanned aircraft drones and manned aircraft, commercial airlines, cargo flights, and even your recreational pilots. And that is also kind of an interesting little tangled web with respect to technology. And it again points to what I was getting at with the opening of the program, that we really do have a love-hate relationship with technology in this country, because technology really can open that proverbial Pandora's box that can lead to a slippery slope where our fundamental and unalienable rights are nearly sacrificed on the altar of public convenience or technological convenience, and that is also something that we should be very cautious about, because sacrificing any type of fundamental or unalienable right for a mere and fleeting convenience is tantamount to sacrificing, essential liberty for a fleeting sense of security. As Benjamin Franklin said, those who do that deserve neither liberty nor security, and shall surely have neither. And that's why it's so important to, again, analyze all of these things within a constitutional framework, applying a constitutional lens to ensure that we are absolutely doing our utmost to safeguard and proactively maintain the fundamental and unalienable rights of the popular sovereigns, we the people. Again, that all ties into the foundational vision that our founding fathers had for this country at the time not only of the American Revolution, but of the Constitutional Convention and beyond. And remember, folks, that they wanted to hand down this natural law system to posterity. It was conceived as a birthright, and we as American citizens, whether naturally born or naturalized, are absolutely the beneficiaries of the greatest birthright of any people on the face of the planet. But as always, it is couched with certain duties and obligations that attach to the fundamental and unalienable rights which were endowed to us by our Creator, and particularly, perhaps chief among them all, in fact, I know it's chief among them all, is the duty to proactively maintain and safeguard our fundamental and unalienable rights. And we should exercise our fundamental and unalienable rights, and we should never have to fear encroachment of said rights by a rogue, tyrannical, or out-of-control federal government. Yet that is exactly what we are currently facing in the United States. Think back to what Obama was saying with his State of the Union address. He was again saying that those of us that want to protect our fundamental and unalienable rights are dwelling in a fictitious past. But nothing could be further from the truth, because you look at this person who was simply attempting to defend his privacy and the sanctity of his home, and you have to wonder whether it's really antiquated to think that we deserve a right to privacy. And absolutely, I don't think that it is antiquated, because as Jeremy and I have oftentimes reiterated on past episodes of the Wright Flyer, our fundamental and unalienable rights are timeless. They will surpass us. They will go on to the next generations for all eternity until kingdom comes, because that is really the natural order of things. And that is what is so brilliant about the type of system that our founding fathers handed down to us. We truly are some of the luckiest, if not the luckiest people on earth to have such a system as we do. And that's what makes it so alarming when you look everywhere and see that there are all of these forces that are attempting to encroach upon, belittle, besmirch, and destroy, to erase all that we have had, because they want to replace it with some idiotic, moronic ideology such as Fabian socialism, which has nothing but a track record of abysmal failure. But that is what we are facing. Everywhere you turn, it is a clash between those that worship at the altar of the state, meaning those who worship government, and those who wish to maintain their fundamental and unalienable rights. And the right to private property ownership is key among those. And so we see that the FAA doesn't really want to do anything about this because they say that they're not handling privacy matters, that they're not equipped to. And the way that it has been handled is you've got this hodgepodge of laws that are being handed out by municipalities, counties, and even states in a rush to create stopgap measures. And a lot of people are wringing their hands and lamenting this fact, but when you really stop and think about it, based on the tenets of federalism, that is absolutely how our system of government is supposed to work. That is why the state governments have plenary power. It is also why the federal government has limited powers, meaning that they must absolutely trace any governmental authority back to a power which is specifically enumerated to them within the four corners of our shared Constitution. You know, that is a brilliant aspect of the system that our founding fathers handed to us. It shows that it was a work in progress, something developed yet divinely inspired by Providence that created the closest thing to perfection that has ever been created by the hands of man. And that, again, just emphasizes the importance that should be placed on having a fluent and working knowledge and understanding of our shared Constitution, and thereby our fundamental and unalienable rights as well. Because it helps us to not only understand the disputes that are arising in this country, many of which are heated, but it also provides us the ability to craft a defense for our fundamental and unalienable rights. And again, that is part of the duty to proactively maintain and safeguard said rights that attaches with the fundamental and unalienable rights which have been endowed to us by our Creator. And it's difficult at times, I know, once again pointing to the sort of rift that this rapidly evolving and advancing technology creates with respect to our rights, because convenience can make us sort of rest on our laurels, for lack of a better term, and that opens the proverbial Pandora's box to the types of encroachments that are typically reserved for rogue, tyrannical, despotic governments. And it certainly goes without question that we have seen our fair share of wannabe potentates right here in the United States. It's shocking, staggering, and very unfortunate that we see that occurring within the bounds of what is the most open, honest, and free society on earth. But again, the evidence is there. Remember that when Barack Hussein Obama first clinched the reins of political power of the United States back in January of 2009, he vowed that his administration, which, as Jeremy and I have both said frequently, cannot actually be referred to as an administration and would more properly be referred to as a regime. But anyway, he vowed that it would be the most transparent presidential administration in the nation's history. And yet we have seen time and time again, whenever scandal just engulfs this regime, they pull rank, they fall back, they circle the wagons, and they obfuscate and stonewall to the best of their ability, which really is distressing, because it shows that they have such contempt for the notion of popular sovereignty, and that they loathe and despise everything that is good and decent about the United States. It reminds me again of what Michelle Obama said during the run-up to her husband's first term of office, when she said that for the first time in her life she's proud of her country. You know, that is a shocking thing to say, and of course the graduates of Pavlov's School of Journalism for the salivating mainstream media just kind of poo-pooed that off, brushed it under the rug, didn't pay much attention to it, didn't think that it warranted much attention, but it's one of those things that sticks out. Kind of like how Obama said that if you own a small business and that you worked hard to create it, well, you didn't build that. The janitor built that. The free loafers in society built that. The, crack whore Sally on the corner of Down and Out Street owns that, or did that. No. You see, again, it shows that they are diametrically opposed to private property rights, and I wouldn't put it past this regime to seize upon this opportunity of this case here between Boggs and Meredith to try and firmly entrench federal rights. And, looking back to the way that the Supreme Court of the United States decided the Obamacare debacle not once but twice, with Chief Justice John Roberts basically throwing the country under the bus, I'm not so certain that they would adhere to the precedents that has been established by that Cosby case. And that too should ring alarm bells for the American people and raise red flags. It all may seem seemingly unconnected here, but I honestly do believe that these are types of questions that we should be asking with respect to this. And again, technology seems to be the vanguard or the spearhead of what is pushing forth to try and cement a new legacy of where government takes more and more and more, and always, each and every time, at the expense of the popular sovereigns, we the people. And so, again, we have to once again realize that it is so important for us to wholeheartedly embrace our fundamental and unalienable rights, and to proactively maintain and safeguard them, because they really are under threat, and we see that this threat grows with each passing day, looming over us like some ghastly shadow or specter of tyranny, despotism, oppression, and just absolute destructive power. The power of the government to use the force of duress to basically force the people to bow at the altar of the state is troubling. We have seen the detrimental and highly divisive consequences that resulted from tyrannical regimes throughout the entirety of the 20th century. You know, World War I brought with it the fall of the old autocratic monarchies, for the most part, throughout Europe, but it replaced them with socialist-style dictatorships like Nazi Germany, fascist Italy, and, of course, the Soviet Union, which absolutely ruled with an iron fist and denied the human dignity of vast swaths of individuals all throughout Europe. And it has had detrimental impacts that have rippled through the annals of history and continue to impact us today. Just look at all of the madness and nonsense that's going on in the Ukraine with Russia. Look at the madness and the nonsense that's going on throughout the Middle East. And then look at the chaos that is all being caused by a president that wants to lead from his behind. But then in the domestic sphere, we find that our most cherished and sacred fundamental and unalienable rights are under an incessant, constant, and deliberate attack. And the people are so caught up in just daily survival that they don't have the energy to expend on proactively maintaining and safeguarding their rights. And it's so interesting that when you look back to the writings of Zygmunt Dobbs, like when he spoke about the devious, duplicitous nature of the Keynesian school of economics at Harvard University, and how that was just used as a plant to spread the virus of Fabian socialism in the free and open society of the United States, you have to realize that that hasn't gone away. In fact, the virus has entrenched itself in more of our institutions of higher learning in this country than even back then. And it shows that with this idea of tolerance, the way that they have corrupted that in the game of semantics that they always play. And remember, folks, we referred to that going back to our first episode, which aired on September 11th of 2015, that these semantics change the meanings of words, but the actual purpose and intent of those who are out to strip us of our fundamental and unalienable rights hasn't changed. It hasn't changed since the dawn of mankind. In fact, Zygmunt Dobbs said that it's funny that they always attempt to couch what it is that they're doing as some newfangled approach or newfangled ideology, when in fact they're going back to the old duress-type system that you saw in prehistory, where might makes right in all instances, and there are no recognized private property rights. And if you recall what Marx said in the Communist Manifesto, and not just Marx, Engels as well, in Das Kapital, they literally wanted to dismantle the entire notion of the private ownership of property. And it's all based on this nonsensical idea that we have linear progression in history. But history is not linearly progressive. It is cyclical in nature. And if we fail to pay attention or fail to learn about it, then we are doomed to repeat the most disastrous mistakes of the past. And that is something that we should strive to avoid, particularly when we have a system that is timeless. So, a system that provides ultimate answers to the ultimate questions is being superseded by nefarious souls who are working to erode the decent framework of it in an attempt to replace it with a penultimate failed system based on the twisted machinations and ideologies of a bygone and failed despotic type of philosophy really should be, rebuffed and rebutted at every available opportunity. And that's why I grow so frustrated with the detente wing of the gutless opposition party, because they are basically stepping into the way of restoring this country, of properly creating gridlock. It's funny, if you recall South Carolina Republican Governor Nikki Haley's response to this last State of the Union address, she's sitting there saying that the people are tired of gridlock. No, they're not. We want the gridlock because we see how things like this idea of the federal government apparently owning the air all the way from 1 inch from the top of a blade of grass to the heavens as being something of a weapon, utilized as a weapon against the true popular sovereigns of this country. And we have no faith that the gutless opposition party will do anything to stand up for our well-established, God-given rights. And I think what really spearheads the anger of not just the Republican base, but of the American electorate in general, and what gives rise to this disenfranchisement that the American people are feeling with respect to this government that supposedly represents them, is that it is clear that the government is not listening to us. It is clear that they sit there and don't even put up an effort to defend our rights. And, folks, without these rights, as Jeremy and I have both lamented on past episodes of the Wright Flyer, what do we have? The fundamental and unalienable rights are the chief designator and mark of distinction between us and any other nation on earth. And you can see that President Barack Hussein Obama does not hold any loyalty or affinity to the idea of American exceptionalism, because he said we're not an exceptional nation. And then we see that there is these administrative, executive branch federal agencies that are creating regulations that somehow become binding law. And in this case, it just happens to be the Federal Aviation Administration. But we've also seen it with the Environmental Protection Agency, which has gone after our traditional power industry in this country. We see the way that they keep trying to front the failed doctrine of green energy on us, irrespective of the fact that it's more costly, less efficient, and doesn't work. And then we also see that they don't punish those who have defrauded the government, such as Solyndra. I'm sure you all recall that scandal and just how horrific that was. It just goes to show that the mentality of the federal government is diametrically opposed to the well-being and to the will and consent of the American people. And that once again draws me back to that startling piece in Breitbart where Pat Cattell said that basically 3/4 of the American population absolutely, right now, as I speak into this microphone, believe that the government is ruling without their consent. That's shocking. But it is absolutely a true reflection of what is going on in this country right now. There is a lot of uncertainty. There is a lot of fear. And that has all been spread thanks to the draconian, heavy-handed tactics of the federal government. And, that really should have no place in a free, open, and honest society like that of the United States of America. Our founding fathers attempted to warn us of this. One of the things that George Washington, our first president and the father of the country, said in his farewell address was to avoid allowing factions to splinter the national identity of the people. Because if they fought with each other and just put up this illusory label that you have these two separate, distinct political entities battling, that they would give up the Constitution just to secure political power. Well, that is clearly what we are seeing being done on the part of the detente wing of the gutless opposition party, or GOP. They are just giving in, collaborating, capitulating, and failing to represent their constituents. And that is a horrendous problem. But again, you're not going to hear any of this from the graduates of Pavlov's School of Journalism for the salivating mainstream media. They're just going to ignore this or say, or, parrot the lines of Obama that those of us that wish to preserve our fundamental and unalienable rights are dwelling in some sort of fictitious past that has no place in a quick-paced modern society like that of today. But no, it does. It does have a true impact. And again, the federal government has been moving slowly with respect to protecting privacy rights, but we know that 32 states have enacted their own laws or resolutions regarding drones. And the National Conference of State Legislatures is the one that put out that information. Yet the specifics vary across the country. Again, that's actually the way that the tenets of federalism is supposed to operate, because the state governments, being much closer to the popular sovereigns, is better equipped, in fact best equipped, to address these matters on the ground. That is why the Founding Fathers designed and developed our representative Republican form of government in the fashion that they did. But we see intermeddling continuing at the federal level, and that is just exacerbating this problem that we're seeing throughout the country. I think that the laws as they exist now can be adapted to apply to this issue. I think that the federal government, or some nameless, faceless, and ultimately unaccountable bureaucracy, would only muddy things, would only attempt to once again deprive us and encroach upon our fundamental and unalienable right to keep and own property. So you see, folks, it's hardly different. Everywhere you turn with this federal government, they are working in a way to not only distract you from the truth, but to rob you of your fundamental and unalienable rights. But as George Mason had concluded when he was called upon to help draft the Declaration of Rights for the state of Virginia, and later helped push through the Bill of Rights, or first 10 amendments to the United States Constitution, the government really can't do that. Not without using due process. Not without going through the natural law processes that have been well established and ordained by our Creator. And that part has just been pushed aside. As over the 20th century in particular, but it goes back before that, we have just allowed the federal government to amass so much, and they have done it so incrementally that we haven't really noticed it. And, this kind of goes to the fact that there were a lot of Marxist adherents that were high up in Abraham Lincoln's cabinet, and Lincoln was a frequent correspondent with Marx, that we start to see that, yes, ever since the American Civil War, we have had this creeping Fabian-style socialism take root in this country. And again, I think it is so apt that the original symbol of the Fabian Society, which they have abandoned due to its negative connotations, was a wolf in sheep's clothing. Folks, that tells you the type of duplicitous type of thinking, the nefarious sort of mindset that just works with these people. And what they are doing is just beyond belief. But think of it, folks. Looking at Nikki Haley, the way that she attacked the frontrunners in her own party because they don't necessarily agree with the detente wing, and the way that she moved to encroach upon the free speech rights of individuals, and the way that she attacked the heritage of the state of South Carolina in the immediate aftermath of that admittedly horrific and tragic shooting at the Emmanuel African Methodist Episcopal Church in Charleston, South Carolina, back in June, the fight against the Confederate flag just shows that weak-willed, gutless opposition parties don't stop the rant against our rights. And it's important to remember that the NAACP had a lot of Keynesian-style doublespeak with it, and it always had ties with the American Fabian Socialist Society. That is something that Dobbs pointed out in a book that he did on race relations in America during the height of the Civil Rights Movement. Now, I am all for equal protection under the law. The United States of America is a nation of laws, not of men. The law applies equally to us all. But what the NAACP has been pushing for ever since it was founded by W.E.B. Du Bois has been to create this sort of gradualist or incremental socialism. And Nikki Haley bought into that hook, line, and sucker. And with respect to the battle flag that was supposedly on the State House grounds, it's important to remember that it wasn't actually over the State House itself, and it hadn't been since 2000. They had worked out an agreement, a compromise, to where it would be over a Confederate war dead memorial, which, by the way, is a museum. So that whole tagline pushed forward by the graduates of Pavlov's School of Journalism for the salivating mainstream media about it needing to be in a museum was a bunch of hogwash. The other part of the compromise was they built the African American Memorial on the other end of the State House grounds. Now that part has stayed. That part of the compromise is there. But the other part of the agreement was breached because of the knee-jerk, cancerous doctrine of political correctness, and Nikki Haley fell into that. Well, when you stop and consider that there are a lot of Nikki Haley types in the gutless opposition party, Benedict Arnold, Paul Ryan coming to mind. After all, he was the one, along with Mitch the Turtle McConnell, who had selected Nikki Haley to give the response to Obama's State of the Union address. What would they do if there was a dispute here over who owns the air rights? And another question is, would this type of story fall into Obama's attempt to try and claim that gun violence is just running rampant in this country? Well, can you really have gun violence against an unmanned vehicle? I don't know. It's funny. I have a feeling that he would be, if he absolutely thought that he could gain some sort of political capital out of it, he'd jump on it in a heartbeat. But what this does show is that technology, whether it comes into just privacy with our electronically transmitted data, or whether it comes to the physical privacy of our homes and the curtilage, or, the immediate area surrounding the home, we should lose those traditional rights, just like we've lost our traditional institutions, just like we've lost our traditional heritage, to be replaced by something modern, because, we're better than what we used to be. No, of course not. And the reason that I say no is that you have to once again recall that our natural law tenets that underpin the entire Constitution and our representative Republican form of government are timeless, which means that they cannot be antiquated, that they will always be equally applicable, just as they were 200 years ago, as they are today, as they will be 200 years from now. But that's a very difficult concept for elitists and those political powers that be that currently wield the reins of political power in this country. They don't want to think like that. They want to think that they know best for us and that they know how to control things. And that's why you see absurdity like the FAA claiming that they own all the air from 1 inch from above a blade of grass to indefinitely. And so, yes, a Supreme Court case said that you can't infringe upon the structures or or encroach upon the quiet enjoyment and use of the land. But what has stopped this government, especially under this tyrannical regime, from ignoring well-established law, pushing forward, creating things at a fever pitch to jump from one crisis to another? Because remember what Rahm Emanuel, the embattled former mayor of Chicago, or he may still be the mayor of Chicago. I know that there's a huge battle about that right now, but what he said: never let a crisis go to waste. And Obama has been a master at that. He has doubled down on that theory, and he has just created constitutional crisis after constitutional crisis in this country. And, you know, when you see a story like this that is seemingly unrelated to all of that, you have to take pause and see how it could potentially be used in that manner. Because the fact that it has popped up, and that there's talk about government regulation, you know that it will eventually come down to that. And the question is, what will our rights continue to be with respect to it? I know what it ought to be, just as I know what the solution to the problems that are currently facing this country are, and that is to return to strict adherence to the fundamental tenets contained within the four corners of our shared Constitution to safeguard and maintain our fundamental and unalienable rights. After all, that is the expressly stated purpose of government. But we've ignored that for far too long now, and there have been so many generations that have started to come up in this country without any realization as to what that is or how that works, and so you start to see that there is a sort of disconnect that we have in the country and between generations, and we can't just bow down to that. But again, I think it's important to pause here for a moment and to go back to the basics of property ownership and to truly resolve the issue on that level. And you know, I mentioned the bundle of sticks metaphor here. This is something that all first-year law students are introduced to. And it's not a unitary thing. And what is unitary about it is the contract that you have through the deed. And so it means that you, as the property owner, have a lot of rights. But the thing is, when you look at the way that the federal government has been acting in this rogue, despotic, and tyrannical fashion over the past half-century at least, you'll see that they have been like a thief of the night, sneaking into your proverbial rights and slowly taking those sticks one by one by one by one, to the point now that there are many Americans who feel that you don't have any right to property whatsoever, because if you fail to pay taxes, they can try and come in and take it, like in the state of California where they removed their homestead law. These are very serious concerns that need to be taken into consideration, because when you stop and actually think about it, the important thing with these rights is that they are fundamental and unalienable, meaning that they have been endowed to us by our Creator, and there has to be some sort of due process before they can be taken away. But even this idea of due process has been used in a game of semantics to where it could be taken away. Look at the contentious eminent domain cases that we have, and you know that connects to the GOP frontrunner Donald J. Trump, who used that power. He used eminent domain in kind of a really nepotism type way with his sister, who is a radical left-wing judge appointed by Bill Clinton to the federal district court there in New York. And it's just, you know, they have to provide just compensation, but it's to be for a public use, except that it's then transferred to a private person because it's said that the public use for this is expanding the scope and application of the tax base. Well, again, folks, that is never what our founding fathers intended for the doctrine of eminent domain to be used for. But back to the bundle of sticks analogy here. What are they? Well, the first stick within the bundle is the right to control or use. So most things which are personally owned, the person who owns them has the right to use it. So if you use, let's say you own a hammer and some nails and some wood, you can use them to make a table. That would be an improvement. But if you don't personally own something, you may also have the right to use, but that would be rental property. But you see, with the heir, that's even more abstract. It becomes more difficult to put down into a concrete way to use. The second stick in the bundle of sticks rights is the right of benefit. This applies to most things that are personally owned. So if you own a chicken, to use the Cosby case, which produces eggs, you can sell the milk for money or the chicken for the money. Or you can, execute the chicken to cook it for dinner or to cook the eggs for yourselves. But we've seen that the right of benefit, through the Keynesian-type mindset that was applied in that disastrous Supreme Court case of Wickard v. Fulborn, again, encroached upon that. When they said, no, you can't do that, you can't grow extra grain to use for your family to save some money, because that detrimentally impacts the Commerce Clause, what is known as the so-called Dormant Commerce Clause, which is an absolute and egregious breach of the Commerce Clause. It clearly a violation of the Ninth Amendment and various other constitutional rights, but it shows that the government is willing to push the boundaries to as far and as great of an extent as possible to gain more influence and power for themselves. And as always, that occurs at the great expense of the popular sovereigns, we the people. It is a disastrous type of notion that has been played out, and again, it just shows why it is so important to have a fluent and working knowledge and understanding of our shared Constitution, and thereby your fundamental and unalienable rights as well. But the right of benefit, it's you can benefit from it. The third is the right of transference. That means you can hand it to somebody. But the way that, say, if you own a firearm and you want to transfer it to your children, the way that this new proposed executive gun-grabbing order by Barack Hussein Obama would work is that some of these would be non-transferable, and that infringes upon the right to transference. So you see, it's not just your fundamental and unalienable right to keep and bear firearms, it's your fundamental and unalienable right to your property right as an owner of the firearm. And that is problematic. And again, it's a thing that the graduates of Pavlov's School of Journalism for the salivating mainstream media will just ignore time and again. And they have ignored it because they don't consider it important. It doesn't fit their propagandistic, twisted, and radical extremist left-wing ideology and agenda. But again, we have to be proactive. We have to pay attention to this stuff. We have to be on the alert, and we have to stand up and say one of the most powerful two-lettered words in the English language, which is universally understood: no. You can follow it with stop it, because they really should stop, because what they are doing is rogue, tyrannical, and illegitimate. But that now, at least going off of what Barack Hussein Obama said in his very last and final State of the Union address, was that that's a fictitious way of thinking, that's lunacy, that it's outdated. But again, these rights are timeless by their very nature, and therefore that is a totally intellectually disingenuous argument being fronted by the current president of the United States. So let's move on to the next one. The fourth right or the fourth stick in the bundle of sticks is the right of destruction. You can destroy your property if you want to, as long as it doesn't infringe upon the rights of other people. But the government can try and block that too. Think of having to get a construction or demolition permit. That sort of thing comes in. And finally, the fifth right, which is the most important one, the one that was, or the fifth stick, that has been at debate or in contention with respect to this drone story that has been the primary impetus of this entire show, is the right of exclusion. And that is, you can prevent someone from infringing upon your property rights. And you can put signs like no trespassing, no bikes, those places that as private places want to prevent people from carrying firearms. If they post the proper signage, then okay, the laws say that you don't have to bring that in. I find that a little more dubious and questionable if you are opening that premises to the public. It's fine in your private house, but a private business that's quasi-public, open to the public, where you are basically now infringing upon the rights of others, that's more questionable. And of course, you're always going to run into certain gray areas with respect to the law, because it's the foundational principles of the law and the supreme law are concrete, unmovable, unshakable forces of nature, because they're based on natural law. But the extraneous stuff that moves around it in our day-to-day interactions with each other and the questions of infringing upon each other's rights, well, that has to be looked at in a case-by-case basis. And of course, the courts don't like to think of it that way because it means more work for them. But it's absolutely the way that a free, open, and honest type of court system, as we have outlined in our shared constitution, would have to work. And so, none of this is an easy thing to address or deal with. Nevertheless, it is something that must be addressed and dealt with. And that's why I thought it was important enough for me to bring this up to your attention. Now, with that said, it is time for me to begin the descent. I'm going to go ahead and send the flight attendant back for one last round of alcohol. So please make yourself comfortable as we bring it home. I want to take this opportunity to thank you for choosing to fly the Wright Flyer. As always, I'm your captain, Randy Wright, and I want to thank you for choosing to fly the Wright Flyer. I invite you to leave comments, posts, concerns, either here on our YouTube page or on our Facebook page or our Google Plus page. Once again, ladies and gentlemen, it's been a pleasure having you aboard. Hope to see you the next time that Jeremy and I take to the friendly airwaves, leaving you with an indelible yet pure sense of enlightenment. As always, do take care, ladies and gentlemen. See you next time.